Committee on State Affairs will come to order. Will the clerk call the roll?
Creighton, Hinojosa, Middleton, Johnson, Hughes.
Much better. Thank you. Good morning. The chair lays out House Bill 1916 by Representative Cook and recognizes its sponsor, the Dean of the Senate, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 1916 is by Representatives David Cook, Brooks Landgraf, Richard Hayes, David Spiller, and Pat Curry. It relates to the jurisdiction of a court in a suit to divide certain property not divided or awarded on the dissolution of a marriage. Generally, House Bill 1916 would clarify that the court which issued the final divorce decree retains exclusive jurisdiction over any actions concerning the remaining undivided property. And that's all it does, Mr. Chairman.
Thank you, Dean. We'll open public testimony on House Bill 1916. The chair calls Carlos Salinas. So we'll show your position as for the bill, not wishing to testify. Very well. Is anyone present wishing to testify on, for, or against House Bill 1916? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. Often the most effective testimony, Mr. Salinas. Thank you for that.
See?
The chair lays out House Bill 1973 by Representative Cook, and the Dean of the Senate is recognized, its sponsor, to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 1973 is by Representatives David Cook and Penny Morales Shaw. It relates to proof of the identity of a child's parents in a suit affecting the parent-child relationship. Members, under current Texas law, there is no requirement for a certified copy of a birth certificate to be filed with the petition in a suit affecting the parent-child relationship. Generally, House Bill 1973 would require that a certified copy of the child's birth certificate be submitted with the petition if it is reasonably available, authorize the court to request the document from another party, or accept alternative proof of parentage if the petitioner does not have access to the birth certificate, and ensure the birth certificate or other proof submitted to the court remains confidential. There is a committee substitute, Mr. Chairman.
The vice chair sends up the committee substitute, and the dean is recognized to explain the substitute.
Thank you, Mr. Chairman. Mr. Chairman and members, the committee substitute was requested by the County and District Clerks Association and differs from the bill as filed. It would require the birth certificate or other proof of parentage be filed separately to ensure it remains confidential.
Thank you, Dean. Any questions for the dean on House Bill 1973? We'll open public testimony on House Bill 1973. No one is registered wishing to testify on, for, or against. Is there anyone present who wishes to testify on, for, or against House Bill 1973? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair lays out House Bill 2530, House Bill 2530 by Representative Cook, and recognizes the Dean of the Senate to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 2530 by Representative David Cook relates to special appointments and suits affecting the parent-child relationship. Members, current law does not require an amicus attorney to meet any minimum qualification criteria prior to being appointed. Generally, then, House Bill 2530 would establish that a court may appoint an amicus attorney only after notice and hearing or by agreement of the parties. Before appointing an amicus attorney, require the court to consider whether the parties can afford it, weigh the child's best interests against the cost, ensure the appointment is necessary, guarantee fair pay for the attorney, and choose an attorney who is properly qualified under the law. It also would set minimum qualifications to be considered for appointment as an amicus attorney. In counties with populations under 500,000, If no trained amicus attorney is available, it would allow a judge to appoint another qualified attorney after notice and hearing or with the parties' agreement. It also would clarify procedures when conflicts of interest arise. It also would set clear powers and duties of amicus attorneys, and it would clarify an amicus attorney cannot give custody opinions, have private talks with a judge, share work product, submit reports, or testify, except in limited cases, and must report child abuse. It also would clarify the court may remove an amicus attorney if all parties agree, and require removal if after a hearing the attorney is deemed unqualified, biased, failed duties, violated standards, or removal was requested due to interference. Thank you.
Thank you. Dean, any questions for Dean Zaffarini on House Bill 2530? We'll open public testimony, and we have Carlos Salinas registered for and wishing to testify. Very well, thank you very much. We'll show you as for the bill and not wishing to testify. Anyone present wishing to testify on, for, or against House Bill 2530? Seeing and hearing none, public testimony is closed. Bill's left pending at this time. The chair now lays out House Bill 4213, 4213 by Representative Dutton, and the Dean of the Senate is recognized as sponsor to explain the measure.
Thank you, Mr. Chairman. Mr. Chairman and members, House Bill 4213 by Representative Dutton relates to the accrual of interest on overdue child support. It was passed unanimously by the House. Members, many Texas families face financial hardship due to unpaid child support, which has reached approximately $19 billion across the state. A substantial portion of this debt is owed by non-custodial parents with limited incomes who often struggle to meet current child support obligations, let alone repay overdue amounts burdened by a 6% interest rate on arrears. Research shows that non-custodial parents who either had no documented income or earned less than $10,000 annually were responsible for 70% of the total accrued child support rearage in the United States. By contrast, debtors with more than $40,000 in annual income were responsible for only 4% of the debt. I think those are significant figures. This high interest rate compounds the debt, making it increasingly difficult for low-income parents to catch up on missed payments and thereby worsening the financial challenges faced by custodial families awaiting support. Generally then, House Bill 4213 would improve collection from low-income parents, change the interest rate on past due child support from the prime rate as published by the Board of Governors of the Federal Reserve System to a fixed rate of 5%. There is a committee substitute that should arrive shortly, we hope, but if I could go ahead and explain it.
So the document is being finalized, but we'll recognize the Dean to explain the substitute, which will be laid out shortly. Please go ahead.
Thank you, Mr. Chairman. The committee substitute should differ from House Bill 4213 as filed, in that it would change the interest rate from the prime rate as published by the Board of Governors of the Federal Reserve System to a fixed rate of 5%. That means it would be lowered from 6% to 5%. And it would require the Office of the Attorney General to include in their biennial report regarding child support enforcement tools metrics about the impact of lowering the interest rate. You may recall, Mr. Chairman, I had a similar bill that reduced the rate from 6 to 3. So this would change it from 6 to a fixed rate of 5, which is different from the House that had a flexible rate. And we do have a resource witness from the AG's office.
Thank you, Dean. Senator, her bill takes it to 5 and fixes it there. Her substitute will take it to 5. I believe, is that right, Dean?
Right.
Please.
Senator Zaffarini, did you previously have an equivalent bill that took it from 6 to 3?
Yes.
I'm sorry, I spaced out a second.
Yes.
And now we're at 5?
We didn't pass that one.
We didn't pass that out of this
No.
committee?
We passed it out of the committee. We didn't pass it through the Senate.
And
So
it
we're
didn't
moving
receive a
this-
vote in the Senate either?
This started as a companion bill,
Uh-huh.
and then the House bill came over and it's different. So we're trying to move the House bill instead of the Senate bill, and it differs. And it differs even more with the committee substitute.
And do we have witnesses testifying on
Yes,
this? Okay,
from
I'll
the
hold my
AG's
questions for
office.
the witnesses.
Thank you.
Thank you, Dean. We'll open.
Thank
Are you ready for the witnesses, Dean? Very well. We'll open Testimony the chair calls as a resource Joel Rogers, Associate Deputy Attorney General for Child Support. Welcome back. Have a seat, introduce yourself, tell us who you represent, and we'll have some questions for you.
Thank you, Senator. My name is Joel Rogers. I'm the Associate Deputy Attorney General for Child Support Legal Services, and I'm here as a resource witness if there's questions on the bill. We did have, I will say, we did have some significant concerns with the 4 amendments that were added to the House bill that completely changed the interest rate from a simple fixed interest rate to a variable interest rate that changes every month. The language is confusing. I'm not even sure, based upon that language, how we would implement that as an agency. I'm not sure how courts would be able to know what interest rates were in any particular month in a consistent way that would allow judges to render orders with the correct interest rate. If you did a 5 years of non-payment, you would have to know what the interest rate was each and every single one of those months by going to the Texas Credit Report website. And we're concerned that anything that involves variable interest rates or anything that requires compound interest rates, which arguably it's not clear in the House bill whether they would be simple interest or compound interest, that's going to create a lot of confusion around the state in terms of getting correct balances and correct judgments and correct interest rates applied. So, and the other part is our computer system that we've designed that's supposed to be implemented next month and deployed next month was designed based upon the interest rate structure that we have in place now, which is a simple fixed interest rates. So whatever the interest rate is, we would prefer it to be a simple interest rate so we could accommodate that without having to make major programming changes to a system that we haven't even deployed yet. I'm happy to answer any questions.
Oh, thank you so much. Let me, I'll take liberty to ask you a couple of clarifications. Thank you for that. Now, I guess there's a couple of moving parts. There's the going from a fixed rate to a variable rate, and then there's simple versus compounded, and I want to make sure I was getting the terms right. So current law, it is 6% simple?
Simple interest. It's been that way since January 1st of 2002. In the last 32 years, we've had simple fixed interest rates in Texas. It's changed once in 2002 from 12% simple. We reduced it to 6% simple in the 2001 session. It took effect January 1st, 2002. We designed our system based upon that, and anything that has to do with having to we're just not set up to handle variable interest rates at this point. It would take some significant reprogram and time for us to be able to get that, and we don't even think that we could accommodate that before the January 1st, 2026 date. So that's our concern. And I think that the proposed committee substitute, my understanding, as I've seen a copy of it, is that it would revert the language back to a simple interest rate, fixed annual interest rate, which we should be able to have in place and ready to go. Whatever interest rate the committee decides, the committee or the Senate or the House decides, we should be able to implement that by January 1st.
And I was going to ask you about that as well. You have seen the committee substitute, and it appears just to change 6 to 5, and then change the 2002 to 2026, and then there's a Mother Hubbard clause at the end that has to do with overdue child support on existing balances. But so you answered my next question. Well, thank you. I bet there are other questions for you. Thank you. Dean, any questions for the resource witness?
No, if you'll stay around in case we have other witnesses with
Thank you.
questions need to be answered.
Senator Johnson, anything right now?
Not yet.
Very good. Thanks. Thank you very much. We may call you back, but thanks for walking through that with
Thank you,
us.
appreciate it.
Sir. Well, again, we'll open public testimony. The chair calls Taryn Champagne, Andrew Ross, Cheryl Johnson. So is Taryn Champagne here? Cheryl Johnson. Please come on down and have a seat. All right, we'll go ahead and start with y'all too. We'll go ahead, introduce yourself, give us your testimony.
I'd like to start, Chairman. My name is Terrence Champagne, and I would like to change my testimony from opposed to for based on the substitute by the senator, and you have my permission to change that. So very similar to this bill, on April 23rd, the committee heard testimony related to Senator Zaffarini's bill, Senate Bill 629, which was a companion bill to this. This would have lowered the interest rate from 6 to 3%. This is lowering it to 5%. I'm in favor of, as it is, lowering it to 5%. In addition to my previous testimony, you may remember Dr. Quinton Reiser from the University of Madison, Wisconsin, testified that studies in Wisconsin had shown that when arrearage percentage had decreased from their 12% to 6%, the amount of individuals who actually paid on arrearages increased. And there was an increased likelihood of paying off those child support arrearages in 3 years. They found that high interest rates were empirically shown to have a discouraging effect on paying off arrearages, and that when it was lowered, those arrearages actually slowed. This lowering from 6 to 5% will definitely assist with that. I want to note that Texas, as the senator laid out, has a huge problem related to arrearages. As of March 2025, there were over $21 billion in arrearages, with over 900,000 individuals in arrears. That's actually greater than the number of individuals with current child support obligations, which sits, as of March, was 736,985 individuals. The intention of the child support system, if it is so, to ensure child have financial support from the non-custodial parent, lowering this interest rate will help with them getting that support. Especially when you consider that the Office of the Attorney General can often be slow in changing those child support modifications. If a parent loses their job, it's very difficult oftentimes for them to get that hearing. So lowering this will help them in the interim by doing that. On the note of child support, right, we have to consider that oftentimes these parents are not even able to, they're basically forced into it when there's a separation. They get the expanded standard of possession order, and Texas is only one of 2 states that don't consider either both parents' income or the difference in time. Senator Hughes, you should be familiar with your own bill, which moved it from, in 2021, 1936, which moved from the standard of possession order to the expanded standard. So these parents are theoretically getting more time with the child. There should be a difference that changes there, but I'm in favor of this bill. This will help them climb out of the debt trap that often happens when they get into arrearages. And with that, I'll close my testimony. Any questions?
Yes.
You want to do it now or after both witnesses?
Yeah, let's go with both of them.
Okay, thanks. Welcome. Introduce yourself. Go ahead.
Good morning. My name is Cheryl Johnson. Some of you know me as I spent many years under this pink dome fighting for property tax relief in my official capacity as Galveston County Tax Assessor Collector. Today I'm here as a grandmother and representing myself, my grandchildren, and the many children of working non-custodial parents. Today, or custodial parents. I had previously provided input on Senate Bill 629, but it never reached you in advance of the hearing. But today I made a point to leave Galveston at 4 a.m. and be here to speak to you. I personally understand the harm caused by unpaid child support. 2 of my grandchildren are being harmed by a father who has chosen not to pay over $24,000 in child support and medical bills. In fact, my daughter had lost her job trying to take one of the children to medical appointments and was missing work, and the non-custodial parent was of no help whatsoever, financially or there to help her. She's since in a much better position, but it wouldn't have been without help. The courts and the Attorney General's Support Division have been little help. Their system, whether it's them or not, but their system appears more sympathetic to the plight of the unemployed than the needs of the unsupported children. They make many concessions and seem to disregard the needs of the custodial parents and children. I have many single moms working for me, some who will never see a dime of child support, and others who will be receiving catch-up child support long after their children graduate from high school. They are the working poor, and they are the ones that need your help. Texas's failing child support system is failing. This system could possibly work if we treated delinquencies there as we do in the tax system. I collect over $500 million annually in property taxes. You, the legislator, have de-incentivized delinquent taxes. The first month, it's 7% penalty and interest, and it increases 2% a month until July, when it reaches between another 15 to 20% is added. So by the time we get to 6 months on delinquent taxes, we're at 33 to 38%. The 20% or 15% goes for the attorney fees that the delinquent taxpayer pays to be sued. The AG, on the other hand, rolls 6 months forward before taking any action. So if any payment is made, they reset the clock to every 6 months, and there's no harm. Further, when tax deferrals were lowered from 8% to 6% to 5%, more people began taking advantage of that. So my fear is you de-incentivize payment of child support, and this is going to make the problem worse, not better. And don't forget, you have supported life, and all those babies that are being born today are going to get added to the rolls of unpaid child support not far into the future. Please demonstrate your support for families in need. Think about the children. Somebody needs to be here thinking about those kids. The families the families that are not being supported deserve financial security. Please vote down this bill.
Thanks for your testimony. Senator Johnson.
Yeah, I think we need a discussion here. We've got sort of conflicting perspectives and perhaps even conflicting objective evidence. Sir, you mentioned, was it a Minnesota study?
In Wisconsin.
Wisconsin.
Senator. Yes.
Somewhere cold. That essentially saw an inverse correlation between interest rates on child support arrearages and the propensity to pay them. Is that correct?
That's correct. That's what the professor presented at the last hearing on Senate Bill 629.
Right. Now, we could draw a distinction there in that the rates there were 12%, which is quite high, and they took it down by half to 6%. You could understand why that would have a serious psychological effect. We might, if we're guessing, and apparently today that's what we're going to have to do, see a similar effect if we cut the interest rate in half from 6% in Texas to 3% in Texas. This moves it from 6% to 5%.
Correct.
Should we presume that that's going to have any effect at all on the kind of the mental suggestion that it makes to people?
If I remember correctly, basically it gave the person hope that there was a possibility for them to climb out of debt, basically, while it was accruing.
Is knocking it down 1% enough to give them hope? And that hope thing's been studied in the 1950s, psychologists. This is great. They put rats in a cage and timed how long it took them to drown. It's kind of sick. It was the 1950s. But it's relevant here. And with some of the cages, right about the point the rats were about to drown, scientists reached into the cage and pulled one rat out, and the other rats kept swimming. This is human nature, and that if there is hope, it's animal nature. If there is hope, people keep going. And so making this move in the interest rate, it doesn't surprise me going from 12 to 6. Might give people help and help them comply. Is moving it to 6, from 6 to 5 enough to pull the rat out of the cage?
I've never been in arrearages, so I
Cage is
can't
the wrong
say.
word, it's a tank, sorry.
No worries. I would hope, but I couldn't definitively say. I would assume that if there's a greater chance to pay it off, you would hope that individuals would work towards that.
And I haven't forgotten you, ma'am. But your approach to this and the findings in Wisconsin is that if the goal is to get people to pay the child support that they're not paying, lowering the interest rate may in fact increase compliance. That's the idea here, right?
Correct.
All right, and we have to guess whether or not that in fact is what will happen. Ma'am, you've stated your opposition, but in addition to that, you brought up a statistic that I wanted you to give me a better idea of what you said. I didn't quite catch it. I think you said you were analogizing this to late interest on property taxes. And I think you said lowering the fees didn't work. Just something about that. What was that?
For property tax deferrals. Well, and they weren't attempting to collect it. What the legislature tried to do in lowering...
Go slow. I want to understand you.
When the legislature reduced the interest rate for property tax deferrals for over 65 and disabled persons, that was to make it easier for them. That went from 8, I think first to 6, and then to 5. I actually worked on that legislation, and that helps seniors and disabled persons. But what has happened is now more and more people, almost half of the tax roll in Galveston Independent School District, the unpaid taxes, is not delinquent when it's deferred. Half of that is now over 65 and disabled deferrals. More and more people are taking advantage of not paying their taxes. So the decrease in the percentage has incentivized people not to pay and take advantage of that tax ability. Now, we don't have...
That's a correlation that you want me to presume is a causation, that we've got more and more people availing, more and more people age 65 and over, availing of the option to defer their taxes at the same time that we've seen a decrease in the interest rate applied to those deferrals. So they've made an economic calculation that I guess if I'm earning 8% in the market and I only pay 4% in my tax deferral, I will therefore defer my property taxes.
Right, so my point there is reducing that interest rate incentivize people not to pay. I believe in this case that if you lower the interest rate, you're going to incentivize people not to pay. It's like, oh, I don't have to pay now. I mean, I get, it's not 6% anymore, it's 5% or it's 3% or whatever. But if you look at our delinquent tax roll across the state of Texas, I can assure you it's not anywhere close to $19 billion. Because
You're talking about the amount of total unpaid child support?
total
It's a
unpaid,
huge problem that we're trying to address for sure.
right, but
But I'm not sure I can correlate that. And I
okay,
don't,
well, when you punish people for not paying their taxes, when you make it onerous for people not to pay, in this case, my example is taxes, they pay. They don't want to lose their property.
Yeah, no,
They
I-
pay. So maybe we need to do something to non-custodial, non-paying parents to incentivize them
so
to
should
pay.
we maybe double their interest rate instead of cutting it?
I think that would be a great idea.
I really
We don't ever
appreciate you
expect to see
bringing-
the 24,000.
I appreciate you bringing the comparison. I'm not sure I think it's I'm not sure that I believe they're equivalents, but I respect you bringing in that for our consideration.
Then consider too, these people who aren't getting paid, these moms or dads, because there's deadbeats on both sides. I can't say there's a gender issue here. But, so they're using credit cards, they're paying 14% interest. And so where are they ever supposed to catch up when they're not having these payments made? And so I don't feel enough consideration is being given to the plight of these kids and these custodial parents who don't have funds to pay. There's some people who are losing their homes, their apartments. I have working moms that are having to leave work because
I
they have no other
appreciate it.
resources to care for their kids.
But I don't think the bill author's intent is to cut a break to deadbeats who aren't paying child support. I think the purpose of the bill is quite the opposite, to incentivize, to increase compliance with child support orders. I think that's what we're trying to do here. You may not agree with the approach, but
I don't agree with the philosophy at all because I've seen the opposite for 20 years in my business.
do you know if judges can impose exemplary fine or fines upon people who don't pay their child support for noncompliance?
I don't know. I'm not a family law attorney.
I'm not an attorney either, but I do know that there are negative enforcement actions for non-payment of child support, such as suspensions of license in addition to incarceration. And even then, when they're incarcerated, when they're not able to earn anything, they still do continue to accrue arrearages on their child support. Same thing with their license suspension, which potentially has the effect of preventing them from even getting to work.
In Harris County, where my daughter lives, they don't put people in jail for non-payment of child support. They don't put them in jail when they commit crimes and kill people. So they don't have room in jail for deadbeat parents.
Thank you both.
Thank you.
Any other questions for these witnesses? Very well, you're excused. Thank you very much.
Thank you.
The chair calls Andrew Ross, Veronica Posada, Judge Carl Hayes. Ms. Posada, you have the microphone there. If you want to pull that a little closer, make sure it's on. There you go.
It is, thank you.
Welcome. Introduce yourself. Give us your testimony.
Yes, my name is Veronica Posada. I am a native Texan. I'm actually native to the capital. I lived here 35 years of my life. I moved out to San Antonio with my 5 children after the non-custodial parent is not in compliance with child support. I found more resources out there for my children and myself. But also, on top of that, I am a child that lived this same cause. My father tried to evade a divorce for 10 years, caused my mom to get a second lawyer because her lawyer died on her. And he never paid child support. For 25 years, he was evading the system. He didn't think that he would have to pay back that child support. And last year, trying to get child support from my own non-custodial parent, I came in contact with Mr. Ross and Mr. Sinkin. They're both lawyers, and they helped me to get that judgment. I don't think parents understand and realize that non-custodial parent, that impact that money does provide to the child. I remember growing up, it could be a field trip or wanting to get something, and you can't because there's no money, and it's true. There is no money. Now with the new laws and the new government that's coming in, even federal funding is being taken away from these families, myself included, and where are we supposed to go? I do understand that there are non-custodial parents that do pay, and they do get arrearages because of COVID and things that have happened, and that does happen, but they do try to pay. But you have a parent that, and I've seen it multiple times, that are evading the system. They can't get the payments because that parent just isn't gonna work. They're living by some of their means. They're getting paid underneath the table. They don't care if they lose their license. They don't care if they go to jail because guess what? They're gonna get 3 meals for free. And guess what? That parent still has to do it all on her own or them on their own. I've seen it both ways. So for you to sit here and say that decreasing from 6% to 5% isn't a problem, it is a problem. Judgments for credit cards, judgments for non-payment of taxes, as Ms. Johnson explained, and I've seen it due to my work. Yes, those people get 7.5, 14% interest on that payment. So you're telling me that that credit card or that tax is more than a child should receive. And to me, I don't understand. And I could never understand that because I live it, and I've lived it my whole life.
Ms. Posada, thank you for testifying, and your story is important to us. We want to make sure we have everything right, and so when you checked in on the bill, the computer is showing you as being for the bill, but it sounds like you're
No, I'm
against the
opposed.
bill. Okay, I just want to make sure.
Yes.
You made it very clear. I want to make sure we have the record correct. Thank you for your testimony. Hold tight. We may have questions for you.
Thank you.
Introduce yourself. Go ahead. Welcome.
Thank you and good morning. My name is Andrew Ross. I am an attorney at the Sinkin Law Firm. For the last 16 years, I have been helping people across Texas enforce and collect long overdue child support. So this bill is very important to me and the hundreds of clients I represent. We and I support the version of the House bill that is before you today prior to the amendment that Senator Zaffarini proposed. What this bill would do, as Representatives Slauson and Hull amended it to, would make it in line with every other judgment in Texas. Currently, except for unpaid child support, every judgment in Texas earns 7.5% compounded interest. This version of House Bill 4213 is good because it recognizes that the women and children of Texas should get the same protection as every other judgment creditor in the state. The original version, which reduced it from 6% to 3%, and I am against that and against any bill that reduces the interest rate on unpaid child support because it doesn't protect the women and children of Texas, and as I see it, provides a financial incentive for people not to pay. Hopefully by now, the members of this committee have seen the KSAT news story on May 13th, which is ABC's San Antonio affiliate, on Senate Bill 629, and have heard the overwhelming negative response to reducing the interest rate on unpaid child support. The original version that reduces 6% to 3%, and the current version as proposed by Senator Zaffarini that reduces it from 6% to 5%, is bad public policy because what this legislation does is it targets the lowest common denominator. It targets those that can pay because there are some who can't. Take, for example, my client Josie Schlater, who was in that interview. Her ex-husband makes $250,000 a year and chooses not to pay child support. I don't think as a law-creating body in Texas, we should incentivize that man and all others like him who can pay that simply choose not to. I think it's pretty clear that interest is a deterrent to non-payment, and if you have someone who's paying child support but also has a utility bill or a credit card bill, rational self-interest would make that person pay off the higher interest rate first because the lower interest rate doesn't accrue as much interest. And we wouldn't be surprised for an obligor to avoid his child support payment to pay off those higher interest bills. No one's also discussing the fact that unpaid child support already gets the benefit of having payments apply to principal first, which is part of 157.268 of the Family Code. So any interest rate that's advertised on paper already benefits. Sorry.
Thanks for your testimony. I want to clarify something. I think you indicated that the bill that passed the House fixes this interest at 7.5%. But the witness from the Attorney General's office said the bill that passed the House has a variable rate, and I believe he's correct. The bill references 304.003 of the Finance Code, so that's not a fixed 7.5%, is it?
That's correct, sir.
Oh, no. I'm sorry, maybe I misunderstood you.
Oh, no, the current rate.
No, so
yes.
we're talking about the bill that passed the House.
The current rate right now for this month is 7.5%.
But we wouldn't want to say that's a fixed 7.5%.
No, sir.
Because
Absolutely not.
It's suggested monthly in the Finance Code. Is that right?
Yes, it is variable.
And that's what you're for. I'm not telling you. I'm asking. Is that what you're?
I am for a bill that puts women and children in line with every other judgment creditor.
So are you in favor of the bill that passed the House that makes it a variable rate, or do you prefer a 7.5% fixed rate? I'm not saying one's better or worse. I want to understand your position.
I recognize Mr. Rogers' testimony that the Attorney General's office would have headaches.
No, sir, I'm not, forgive me, I'm sorry, I'm not trying to be difficult. I know that he had some practical problems with the variable rate. Are you for the variable rate passed by the House, or are you for a fixed 7.5%? That you testified about? I'm not fussing at you. I just want to understand your position.
Yeah, I'm for a simple rate. I think that would be the easiest thing for the state.
Now, simple as opposed to compound, or simple as opposed to, you mean fixed as opposed to variable?
Yes.
Okay, because the bill that came out of the House is not a fixed rate.
That's correct.
It's a variable rate.
Yes.
Okay, that's fine. I just want to make sure I know what you're for.
Yes,
okay.
sir.
Okay, thanks. Judge, welcome. We may have questions. Judge, welcome back. Welcome to this committee. Introduce yourself. Go ahead.
Thank you. My name is Carl Hayes. I'm the judge of the Family Court of Hayes County, Texas. I've been the judge for the last 6 years. As the judge of the Family Court, I have responsibility for the majority of family law cases that are heard in Hayes County. I am not here testifying in my official capacity as judge of the Family Court. I'm here testifying as an individual. I am in favor of the legislation, and the reason I'm in favor of it is because the empirical data supports this legislation. And as you've heard in previous testimony, Wisconsin has been on the forefront of this. Wisconsin did studies on lowering the interest rate, and it had a positive effect, taking into account all of the other possible causes. And Wisconsin's done other programs too, but this program of cutting the interest rate increased the ability to get current child support. We're not talking about getting the past amount of child support. It's making sure that people can pay their bills this month and the mothers can get the money this month. So it increased the ability of the child support obligors. They made their payments for current child support. And my understanding of the committee substitute that the senator laid out is we're going to have a component in this bill that's going to check to see the efficacy of it. And the Office of the Attorney General has to report back as part of this bill about whether it's working or not. And if a 1% decrease, Senator Johnson, it shows a benefit, perhaps then maybe later sessions could say we take it down because, yes, Wisconsin went from 12% to 6%, and they saw a marked difference and a favorable difference. It increased the amount of current collections. And you asked the question about whether a court can fine. A court can fine, and I'll tell you, in every child support order, there is language in big, bold letters that says if you don't comply with this order, you can be held in contempt, you can be fined up to $500 per violation. that $500 doesn't go to the mother that's owed the money, it goes to the state. That's not a benefit to do that. And so it's not helping. Plus, me throwing someone in jail is counterproductive too, because we want them to work. We want obligors not to lose their jobs. And if I'm telling someone, I'm gonna suspend your license where you can't work, or I'm going to, this is the problem the 4D courts have all the time. They have to balance trying to enforce these orders, get people to pay, and yet not put them in a position to where they're unable to pay because they've lost their job, or because they're sitting in jail, or because they have this mountain of debt they can't get out from under. And I'm in favor of this because the statistics show that a decrease works. And I will yield for questions.
Thank you, Your Honor, for your testimony. Senator Johnson, do you have, you go ahead, thanks.
Thank you. Sir, there in the middle, you mentioned, as did a prior witness, that somebody who's got high credit card rates, of course, is going to pay off their 24% credit card interest or arrearage before they're going to pay off a child support delinquency, right?
Yes, I would assume so.
And whether we have this at 5% or 6% or 12%, they're still going to pay that credit card first if they're just comparing interest rates. If that's the calculus, right?
Under that scenario, I believe so.
So I'm not sure that moving the interest rate is going to have any effect if somebody's making a pure interest. We want people to pay child support because they're taking care of their kids.
Absolutely.
Right. Okay, you're not proposing that we raise child support delinquency interest rates to match that of, say, credit card interest rates?
Oh, absolutely not.
Okay.
No, I'm proposing to just, at this point, with all the different options, I think we should table everything, have a meaningful discussion with all the stakeholders about what might actually be best to increase the payment, because I believe no matter how the bill looks, that's what we're all after.
Want to increase compliance?
Absolutely, increase compliance so the mother, the children, those fathers who have custody of their kids actually receive the child support. And if I may, the part of Senator Zaffarini's proposed bill would require the Attorney General's office to twice a year say, hey, does this work or not? Well, my suggestion is why kind of shoot first and ask questions later? Why don't we look at the 32 years of data we already have in Texas, not Wisconsin? Because in Texas, we already reduced the interest rate from 12% to 6%. As Mr. Rogers stated,
When was that, sir?
That happened back in 2002. So from 1993 to 2001, the interest rate was 12% simple. From 2002 forward, it's 6%. So in Texas, with the Attorney General's system, we have 32 years of data to look at and pull from. Why not study that data rather than look at Wisconsin, who the literature, as you suggested, states inside it that this may have the complete opposite effect. They don't really know, and nor do they know how it affects Texas. Texas has its own data. I believe the better path forward would be to research that, study it, see what happened when we reduced it from 12 to 6, see if that actually increased compliance. Now, there's a number of statistical factors. Are there more people in the system? Are people making more money? So the data can be skewed, but I think it's important to study it rather than try to rush forward something in the last 10 days of the session so we can reduce the interest rate. I don't think it works. I think the interest is a deterrent, but Texas has its own data. Let's study that. Let's get everyone involved, the Attorney General's office, the private bar, your offices. Let's see what Texas shows, and let's see if actually reducing it from 12 to 6 did anything. I think all the data's there.
Thank you.
Any other questions? Judge, Counselor, ma'am, thank you all for being here.
Thank you.
Thanks for your testimony. Thanks for taking time to be here. Is there anyone else present wishing to testify on, for, or against House Bill 4213? Public testimony is closed, and as a matter of housekeeping, Dean Zaffarini explained the substitute to us, which The copies have been distributed, so Senator Johnson sends up the substitute. It's already been explained to us. It's now before us. And we will leave this bill pending at this time.
Thank you, Mr. Chairman and member.
The chair lays out House Bill 2524 by Representative Cook and recognizes its sponsor, the Vice Chair of the committee, to explain the measure.
Thank you, Mr. Chairman. House Bill 2524 simply renders the language regarding attorney's fees in the Family Code consistent. Sometimes it says reasonable, sometimes it says reasonable and necessary. We all recognize in the practice of the law that attorney's fees must not merely be reasonable for the services provided, but they have to have been necessary in the course of the litigation. This basically update to the code makes sure that all references to awards of attorney's fees be in the case where the attorney's fees were both reasonable and necessary.
Thank you very much. We'll open public testimony and ask if anyone present wishes to testify on, for, or against House Bill 2524. We have Mr. Salinas with the Family Law Foundation registered for the bill. Do you wish to testify? All right. You've set the bar pretty high so far. So.
Well, thank you very much. I appreciate
your time.
Of
course. No, glad to have you here. Welcome. Introduce yourself. Go ahead.
My name is Carlos Salinas. I'm a board-certified family lawyer here in this area. I've been practicing family law for 20 years. I'm also a member of the board of directors of the Texas Family Law Foundation. I believe that Mr. Johnson has very effectively laid out this bill, and I'm here to answer any questions and simply say that my organization, the Family Law Foundation, and I personally are in support of this bill.
Thank you very much. Senator Johnson, any questions?
Appreciate you being here.
Thanks for being here. Thanks a lot.
Thank you very much.
We'll ask if anyone else present wishes to testify on, for, or against House Bill 2524. Seeing and hearing none, public testimony is closed. Bills left pending at this time. The chair now lays out House Bill 3180, Representative Dutton's bill, and recognizes the Vice Chair of the committee to explain the measure.
House Bill 3180 provides an opportunity to use a word that's seldom used here. We usually say typo, but this is actually a scrivener's error. This is not a typo. We're fixing a scrivener's error where somebody wrote the word settlement instead of statement in reference to a witness statement. So we're correcting that. We're changing the word settlement to statement in the context of discovery under the Texas Civil Rules Civil Procedure to match what was intended originally. It's exciting, right?
It certainly is. Wow. It was pretty important. I mean,
No, it's actually an important change, even if it was just a scrivener's error.
that's got a V in it, Scrivener, right? Scrivener.
Yeah, S-C-R-I-V-E-N-E-R apostrophe S.
Thank you. Thank you. That's, thank you for doing this. When we do it, we'll open testimony on House Bill 3180. House Bill 31, it looks like Judge Hayes is registered on that bill. Your Honor, come on.
I have lengthy testimony to give. I'm going to take a cue from Mr. Salinas. Unless you have any questions, we just need to make the change.
Thank you, Judge. Thanks for being here. Thank you. We'll show you as for the bill. Thank you. Anyone else wishing to testify on, for, or against House Bill 3180?
Bartleby? Nobody? Nobody knows that one? Bartleby, the scrivener?
Oh,
Okay, never mind.
man.
It's a short story. Charles Dickens.
Vaguely familiar to some of us, and more others. There's no one wishing to testify on, for, or against. We'll close public testimony, and bills left pending at this time.
4-0. Okay. Chair calls on Senator Hughes to lay out House Bill 40.
Thank you, Mr. Chairman. House Bill 40 is the companion to Senate Bill 2883, which is left pending in this committee. And of course, this is the update on the business courts created last session and up and running only since September, and very encouraging, a great success by many different metrics, and sure encouraged to see how those things are going. House Bill 40 is identical to Senate Bill 2883, with the exception of a few House floor amendments to make minor clarifications to the removal process, remove outdated judge appointment directives from last session, and make sure that counties are reimbursed for court construction costs, because the counties are called on to provide space in some settings. There's a committee substitute, Mr. Chairman.
Chair calls on Senator Hughes to lay out to explain the differences between the original bill as filed and the committee substitute.
Thank you, Mr. Chairman. The committee substitute addresses the supplemental jurisdiction and makes that consistent with the original language passed by the legislature last session. And that, again, as the courts are relatively new in practice, the thinking is to keep that consistent and let that continue to play out and get some more feedback from litigants and judges as we go forward. So committee substitute will take the supplemental jurisdiction process and language and revert it back to the bill passed last session and the current practice. And I'll yield.
I don't have any questions at this time. We do have a total of 0 witnesses registered. Is anyone who wishes to testify on, for, or against the committee substitute to House Bill 40? Seeing and hearing none, public testimony is now closed. Bill will remain pending. Chair calls on Senator Hughes to lay out House Bill 3421.
Thank you, Mr. Chairman. This is the companion to Senate Bill 1448 that was passed unanimously by the Senate. It updates probate procedures so that original wills can be physically transferred by a qualified delivery method, and it treats paper copies of missing wills like originals. Sets a 7-day deadline to notify heirs of temporary administrator appointments, and adds statutory probate courts to e-filing requirements, which are pretty much uniform across Texas courts now, courts of record. Pardon me. The bill makes additional clarifications in the Estates Code to streamline probate administration procedures. I can go into more detail, which I'm sure would be riveting, but that's what the bill does.
Anyone wishing to testify on, for, or against House Bill 3421? Seeing and hearing none, public testimony is now closed and the bill will be left pending. Chair calls on Senator Hughes to lay out House Bill 4170.
Thank you, Mr. Chairman. House Bill 4170 is about venue for lawsuits involving private transfer fees on real property. Since 2011, these fees have been restricted and there are enforcement rules for them, but the statute doesn't say where lawsuits related to private transfer fees in existence before 2011 must be filed, so there's some uncertainty. This bill requires those lawsuits, except for those by the Attorney General, to be filed in the county where the property is located. It's about clarity and fairness and convenience for property owners, and with that I yield.
We have 2 witnesses registered, Francis Blake and Thomas McMurray. Please come up, state your name and your position on the bill.
Thank you. Good morning. Francis Blake on behalf of the Texas Association of Builders. I'm the general counsel. As Chair Hughes just laid out, that this bill really helps close a loophole or streamlines a venue provision that's in the Texas Property Code for these private transfer fees. So this gives clarity to litigants where venue can be held and should be held. Senator Johnson, I think Bartleby was the answer to your earlier. Bartleby was the answer to your earlier question.
That's right.
That's a
Bartleby's
great
Scrivener.
short story.
Yeah.
Yes. Thank you. Happy to answer any other questions. Thank you.
Thank you, Chairman. My name's Thomas McMurray. I go by Tom McMurray. I'm a 34-year real estate litigation lawyer who's tried 400 trials, and this will help a lot of citizens in the state. The issue under 15011 of our civil practice remedy code for 150 years is a land suit should be brought in the county. But gamesmanship's been going on, and you're allowing Miss Smith, who doesn't even know there's an issue, to get brought in a lawsuit that lives in Paris to have to be all of a sudden where some trustee is in El Paso, and by just pure cost, they burn them down. I would be highly in favor of this, and I'm happy to say that the House unanimously voted for this. So I'll yield to if you have any questions.
Senator Hughes, questions? No questions from me. Thank you both for testifying today. Is there anyone else wishing to testify on, for, or against House Bill 4170? Seeing and hearing none, public testimony is now closed, and the bill will be left pending.
And the chair lays out House Bill 3783, where Representative Hull and recognizes its sponsor, our colleague Senator Parker, to explain the measure.
Well, good morning, Mr. Chairman. Members, thank you for the chance to come before you this morning, and thank you for your patience in waiting for me as I came from another committee, in laying out another bill. Thank you very much. This bill places limitations on the types of counseling that a family court may order a parent to or child to participate in. What some call reunification therapy is a pseudotherapy that claims to repair the relationship between a child and their non-custodian parent. However, this unregulated practice often involves forced overnight or out-of-state stays for children away from their custodial parent, using private transporters that engage in force and threats, so-called therapies that are not evidence-based, and the use of physical threats or coercion or isolation of the child. This purported treatment alleges that it can rebuild relationships between children and an estranged parent, but it tries to do so by dramatically breaking the relationship between children and their primary custodial parent through no-contact orders, physical abduction, and removals to camps, and threats of consequences of reporting noncompliance back to the court. These are not custodial parents who are involved in a CPS case or have been investigated by the state for abuse or neglect. These are often normal, loving parents who often during the separation from an abusive partner face further abuse that isolates them from their children with little to no oversight. I want to be clear, members, that this bill does not ban the concept of court-ordered family therapy. The bill simply places legal guardrails around this practice, particularly by banning forced separation from the primary custodial parent. If a court wants to order therapy between the non-custodial parent and the child, the court can certainly do so, but they cannot make a removal or no-contact order against the custodial parent for that therapy. That decision should be made in the course of a true custody hearing, not through the back door of therapy. And again, I appreciate you allowing me to lay out the bill. We do have some excellent witnesses here to speak to these programs here today that have really experienced all this firsthand. And just appreciate the committee's consideration of HB 3783 and the chance to come before you here this morning and lay it out.
Thank you, Senator Parker. Any questions for our colleague on 3783? Very well, we'll open up testimony, and we have two invited witnesses. The chair calls Jeff Diamant, Abigail O'Brien. Have a seat anywhere, any of those at the end or on the side, wherever you're comfortable. There you go, that's great. Welcome, introduce yourself, get close to the microphone or get it close to you and give us your testimony.
I find if I get too close to the microphones, they'll echo because I tend to talk a little louder than I should. But my name is Jeff Diamond. I am an adoptive father to two girls, Sophie, 21, Sadie, 18. I am the husband to my amazing wife, Angel, who now works in this space with me and is the mother of my two children. And I am an attorney of 30 years who practices in the family courts daily. It is my wife that opened my eyes to what's happening here, which I honestly couldn't believe when I first got exposure to. It took me quite a while to come around to the horrors of reunification therapy that it really is in fact occurring. My girls were on a roll their entire life. They were captains of the soccer team. My oldest daughter has just completed her third year in Auburn University's architecture program. My younger daughter just graduated high school this past weekend with highest honors. They were victims of the family court system in an attempt to force a relationship with an abusive parent who was the former chair of plastic surgery of a very prominent hospital. He's now banned from the hospital grounds in its entirety and was removed from his position. Who, when he was not abusive, was often absent for years at a time. He used alienation and reunification therapy as a court tactic to extend the litigation. Even when my wife moved literally on the same street as their biological father to try to foster that relationship, yet false claims of alienation and forced reunification therapy were allowed to stand in the family courts. That is after 8 years of litigation, over $1 million spent out of their community estate, and it's ended by the father, let's say, appropriating the children's 529 funds for his personal use. I have lived this, I have seen it, and I fight it on a daily basis. We have, should the committee ever need so, a chronologically ordered file that we can provide you that demonstrates how this is used as a court tactic to extend litigation by abusive parents. Even the purveyors of reunification therapy refer to it as, and I quote, a symbolic experimental intervention. A symbolic experimental intervention. That's in their own documentation. That is therapy that is being ordered by the courts of this state. It is the functional equivalent of allowing a state court to order you to place your minor child in an experimental drug trial. There's no difference between the two. This program was built off of a purported psychological construct that was developed by a psych who was openly in favor of both incest and pedophilia. Absolutely factual. It has never been approved by any psychological agency, and none of this has ever been approved by a purported treatment. It has no training, no studies, no science, no certification, and no regulation of any kind. It involves isolating a child from their safe parent, in many cases for years, with no contact. It isolates them from their school, their friends and family, and even their therapist. It includes transportation by force, taking children out of homes, off school buses. It sequesters them in undisclosed locations, and it typically involves the flipping of custody to put the child into the hands of the abusive parent. I can tell by your faces that this is as difficult to grasp as it was for me, and I practice in these courts and I see this. But what I am telling you is 100% true. This technique is used to shift the focus from the wrongdoer onto the protective or safe parent, accusing them of abuse solely for trying to protect their child from an abusive parent. It has become a weapon allowing abusive parents to try to use children as pawns to punish their parents. I have seen it, and I am here first and foremost as a father to two girls who went through it, as a wife who went through it. I am here second as an advocate for myself, for my clients, and for all of the families who suffer from this. This bill seeks only to make impermissible this unlicensed, unregulated experimental program. As Senator Parker said, it does not prevent necessary psychological interventions for a child in crisis, for example, nor does it prevent the use of licensed and regulated therapeutic programs that are tested and scientifically established. With that said, I would open myself up to questions should the committee have such.
Thank you, and we want to hear from Abby in just a moment, and Senator Johnson may have questions, but I know we're going to learn more as we hear witnesses. I want to clarify one thing. There's a suit affecting the parent-child relationship. There's a possession order that has to do with the child spending time with each parent. And we're probably going to get to this, but I want to make sure I'm clear. Are you telling us that when this therapy is ordered, that can supersede the possession of the child, which would normally be under the order of the court?
Yes, that's
and you've seen this in family law cases in Texas?
Yes.
Okay, well, we're going to learn more. Thank you. Senator, questions before we hear from Abigail? Very well. Abby, welcome. Get close to that microphone and introduce yourself. We want to hear from you. Glad you're here. Go ahead.
Thank you, Chairman Hughes and members, for giving me this opportunity. My name is Abby O'Brien, and I'm here in support of Senate Bill 3783. My younger brother and I were subjected to Lisa Rothfuss's intensive reunification program in March of last year. We then went through a no contact with our mom, which lasted about these 70 days instead of the court-ordered 45 days until our case was transferred to a different judge. Through this program, we were subject to coercive conditions in which my brother and I quickly learned to keep our mouths closed and do everything that was asked of us if we wanted to see our mom again. We were told my mom was abusive, manipulative, mentally ill, a liar, and that we had false memories, but were never given any reason as to why they believed this. Lisa Rothfuss never gave any proof or empirical evidence. Instead, she hides behind cartoon videos, threats, and this idea of parental alienation syndrome that isn't recognized by the APA. We were shown the Texas Children's Bill of Rights and told that it didn't apply to us in this situation. Our technology usage was heavily monitored, and despite being promised phones to keep up with school extracurriculars, they kept being withheld under the pretense that my mom was refusing to participate or not doing what she needed to do. Later in the no contact, we were told that the court needed our passwords for everything. I called our guardian ad litem, Kelly Baker, and my dad's lawyer, Ann Wynn, who both confirmed this. It was just another lie. At times, we weren't allowed to contact or speak to our older sister. We were banned from talking to or going to the houses of family friends, and I was banned from going to one of my best friend's houses because my dad claimed her family was bad-mouthing him or refusing to listen to the truth. These programs isolate kids from the people they trust, people that will protect them and make sure they're okay. I lost a lot of friends because I was so afraid that they would be taken away or believe the lies my dad was spreading about my mom, but I also wouldn't have been able to make it to where I am today without the friends who were there through all of it. Bringing me and my brother food to school, making sure we got to practices, and most importantly, being there and making sure we knew it would all be okay when my mom wasn't allowed to be there to do it herself. I was scared to speak out and scared for my younger brother's safety and mental health. There was no one there to advocate for us but ourselves, and no matter how perfectly we followed all their rules, it doesn't matter. If we don't show their version of growth, which changes often, we are told that time would be extended. In every case, time is always extended. Despite what we were told, despite every part of me knowing it wasn't true, we never outwardly questioned it because we were afraid. I first heard of reunification programs when they started using them as a threat to get my brother and I to do exactly what my dad or Mrs. Baker wanted, and I was horrified by what I found within a simple Google search. After participating in the program, I knew I couldn't allow these unethical practices to continue. As terrifying as the thought is, my brother and I were extremely lucky. Lucky in how old we weren't forcibly taken out of state like many kids, and we happened to get a new judge at the right time who ended it. Most importantly, we had each other. I started a Change.org petition to enact Caden's Law in Texas in hopes of bringing legislative attention to the issue, and wrote to countless representatives and officials in hopes that anyone would listen. Children's voices are so overlooked, but in these cases, they are completely silenced. After everything he put us through, my dad hasn't spoken to me or my little brother in 4 months. He has a girlfriend now, and around the same time decided to stop coming to family therapy sessions, handing us notes with something like he would be waiting for us when we were ready to accept the truth. He is a vocal advocate for intensive reunification programs and against parental alienation online, but decided he wasn't willing to put in the effort of having a relationship with us. No child should ever be forced to choose between safety and a relationship with a parent, and no child should be subjected to treatments that are ineffective, unethical, or set up for an adult's personal profit. I not only urge you, but beg you to consider supporting the passage of the Safe Haven Act. Thank you for your time and your commitment to supporting and protecting future generations of Texans. I'm open to any questions.
And thank you for your testimony. It's rude to ask a lady, but how old are you?
I'm 18.
18 years, all right. And
Yes,
so thank you for telling us what you've been through. Give us an idea of what the setting is now. So you're with your mom now, as far as custody goes, or?
Yes, sir. I live with my mom full time, both me and my younger brother, but I'm going off to college soon, so.
All right.
Yeah.
Where are you going?
I'm going to Tarleton.
Outstanding, outstanding. Thank you. Senator, any questions?
No, thank you.
Thank you both for being here. Thank you. Thank you very much.
Thank you.
Warren Charleston, yeah. Chair calls Judge Carl Hayes. Jennifer Mudge. Paul O'Brien. We have you here as on the bill. I'm going to ask you to go first and on a new bill, so introduce yourself, tell us who you are, and give us your testimony. We'll probably have some questions for you.
Certainly, Chairman Hughes, members of the committee. My name is Carl Hayes. I have the honor of serving as the judge of the Family Court of Hays County, Texas. In my capacity as the judge of the Family Court, I handle essentially the majority of the family law cases in the entire county. I am the associate judge for 6 different district courts that all have jurisdiction in Hays County. I am not here testifying as a judge. I'm also here testifying on the bill because I cannot take a position on this type of therapy. As both of you know as attorneys, Each case is different, and if someone comes in urging a particular expert therapy under Rule 702 and 703, I have to listen to the evidence that's been presented and make a determination on the evidence presented in that particular case about whether or not I should give any credence to the theories that are being presented to the court at that time. The problem I have is on line 20 of this bill. Line 20 of this bill deletes the authority of any court to order the payment of counseling. And that's any type of counseling. And so the problem is we're throwing the baby out with the bathwater because this section of the Family Code, 153.010, is the section that authorizes a court to order any type of family counseling. And you had Senator Parker talk about, well, this doesn't stop an individual judge from ordering family therapy with a licensed therapist that doesn't involve reunification therapy. It would stop me because I can't authorize someone to pay for it. If I wanted to do therapy between dad and a child saying, you guys need to go have some therapy sessions before I can ramp up possession and access, I can't order that to be paid by anybody. If I'm saying mom and dad have to go to family therapy just to talk about communication issues, I can't delegate the cost between the two of them because this legislation removes my ability, and I don't understand why that section was cut. I think a simple solution, and I'm not debating the merits of any other part of the bill, a simple solution that would solve my concern is just put back in line 20. I don't see why it was taken out.
Line 20, which page?
Line 20 on the first page, it just says, the court may order a party to, and it says pay the cost of counseling. And there's no reason for that to have been deleted. If you want to make it specific as to this reunification, you could put it under the C and D sections that are being added and say a court can't make a party pay the cost, because I know there's some discussion about whether they make the offending party pay or whether it's fair to make the party who's the alleged parent being alienated pay, and I understand that. That's part of that discussion, but there's clearly no reason to take out this section that says that the court can order a party to pay the cost of the counseling. It should be put back in. And I'll yield for questions.
Your Honor, thank you for that. And let me ask you a couple more questions, if
Absolutely.
you don't mind. I tell you what, if you don't mind, if you'll stick around, I'd like to hear from these witnesses.
Absolutely.
But please keep your seat, because I'm going to have some questions for you after they testify. If you don't mind, you're loud and clear on your testimony. We're going to rely on your experience a little bit more, if you don't mind.
Yes,
So, Mr. O'Brien, introduce yourself. Give us your testimony.
Yes, sir. My name is Paul O'Brien. This bill keeps a child from being in therapy, and if you'll notice at the beginning of the bill, while it was referred to as dealing with reunification programs, it actually just says counseling in the bill, and so it effectively deals with any form of counseling. What I'm concerned about is that this addresses when kids most urgently need it by making it illegal for the judge to order the kind of counseling that is sometimes required to fix a broken parent-child relationship. Yes, my name is Paul O'Brien, and you did just hear from my daughter. We are obviously on opposite sides of concerns for this bill. My ex-wife also testified previously in the House. Let me explain why it's problematic. It bans key tools effective for therapy. If you look at Section D, it prohibits counseling if the therapist requires temporary separation from a parent, even though if that parent is psychologically abusive. It also does ban overnight stays. However, a court might request that, or the clinicians involved might recommend it. It means that if a child is refusing to be with a parent because of manipulation, fears, or lies, this bill prohibits therapy proven to repair the relationship. You've heard that the science is not sound in this. You've heard that the evidence is not clear about whether or not these programs work. I'm here to counter that with that evidence. And as an example of it, most of the common interventions used in severe alienation cases, such as what I've been through, are banned by this. It removes court discretion in favor of blanket prohibitions. Just as the judge just testified, the judge weighs the facts, they hear the experts, they determine what's in the best interest of the bill. This bill says they can't. They have to ban certain categories of therapy. When a judge finds that a child is being emotionally manipulated, for example, the court can no longer order therapy to allow the child to spend time away with the psychologically abusive family member. Let me explain why. It ignores the difference between abuse and family conflict. Section C says that there's credible evidence of domestic violence or sexual abuse. Then counseling between those parties can't be ordered. I think we'd all agree with that. What the language doesn't use is the full definition of abuse, which is actually already written into the Texas Family Code. Why wouldn't it just say abuse? I think it should, any form of abuse. The bottom line is this therapy works, and I appreciate the opportunity to be here.
Thanks for your testimony. Welcome. Introduce yourself. Pull that microphone close. Go ahead.
Hi, my name is Jen Mudge. I'm a public policy manager with the Texas Council on Family Violence. Formerly worked as a mental health therapist, and I'm here in support of the bill. Thank you for the time to speak, and thank you to Representative Hall and Senator Paxton for bringing forward this bill. So the bill makes it clear that victims of family violence, including children who've been victimized, should not be compelled to attend counseling with the person who abused them. Therapy of any kind is most effective when participants can be honest about the issues they're addressing. In situations of family counseling, it's assumed both parties have an equal voice. In abusive relationships, that is absolutely not the case. Forcing a victim to be in the same room in a counseling session with an abusive partner, especially during a dangerous time of separating from that partner and determining custody and parenting time, increases the risk of violence. This bill would ensure that that kind of dangerous dynamic is no longer going to occur. The bill also addresses practices that are harmful for victims in family counseling, such as family reunification therapy. It's not evidence-informed, and it's often a response to claims of parental alienation syndrome, which is also not evidence-informed and is discredited as any kind of diagnosis. FRT in the context of family violence is not only extremely harmful to children who are ordered to complete it with the person who abused them, sometimes their parent, but it can mean that the child's actively removed from the parent who fostered their safety, sometimes for, as we've heard, prolonged periods. When this happens, the court shifts the focus from child safety to the abusive parent's needs and wants, often creating fear and forcing children into unsafe or traumatizing interactions. Parents' rights are, of course, vitally important, but if a parent abuses the child's rights and well-being have to take precedence. So this bill paves the way for safety for victims and their children in family counseling under SAPSR cases and introduces some important protections and would really prevent victims from experiencing further trauma at the hands of someone who's already harmed them within a setting that's meant to foster growth and healing. And I do also have some written testimony from a survivor to share who wanted to share her experiences with family reunification therapy and the challenges that she and her children have faced. So I have that here.
Please do share that with us. Thank you. I've got some questions, but I'll yield to the members of the committee if y'all have anything first. Okay. Your Honor, we recognize that you're a member of the third branch, and we're not asking you to testify in your official capacity. If you're comfortable, I'd like to ask you some questions about your experience as someone who's handled these cases as a practitioner and as a judge.
Yes, sir.
You're comfortable with that?
Yes, I am.
Thank you. The question that I asked the first witness, and I think I understand the answer, but help us understand that there's a standard possession order in place. Obviously, the court has discretion to make changes as the court sees fit. Has it been your experience that therapy, that a judge would allow a therapy, the application of which would interfere with that possession order that the court had put in place?
There are times that happens, and that's because it's not unusual for a judge, when they're ordering therapy, to also add to the order that the parties are to follow the recommendations of the therapist. And so I set out a standard possession order, but I say, you're to follow the recommendations of the therapist. And in this instance, let's say it's a reunification therapist, and what they're trying to prevent in the latter part of this is the therapist says, well, we're going to have to go do this weekend camp situation. And I've ordered the parties to comply with the therapist's recommendation. So that basically takes the place of my order. Now, there's appellate authority for the proposition that a court can't delegate carte blanche the authority, and I still have to retain the jurisdiction. So if someone wanted to, they could come back into court and say, Judge, we're being asked to do this, and we want you to say whether or not this is appropriate or not. But 9 times out of 10, people don't do that because the initial order of the court is, you guys obey you follow the recommendations of the therapist. They would still have the right to come back in, but most people don't know that. And they just see the order that says, we've got to do what the judge says, we've got to follow the therapist's recommendation, and so that's what we're going to do.
That makes sense, Your Honor. As you mentioned at the outset, the court needs discretion to consider, to weigh a lot of different matters and to make the right rulings. If you're comfortable telling us, have you had experience with the type of therapy that's being described here?
I have not. I have the most, this is a relatively new type situation. I've been practicing law for 40 years, and about the only time that I've had something drastic being proposed is that oftentimes a therapist will propose that a judge order possession that excludes the other parent. Not that they go to therapy that involves that, but just to say, look, you need to have a period of 30 days or 60 days where the other parent doesn't have any contact. That's the most I've seen and the most I've been requested to do. I've never been asked, Judge, order somebody into this program or to this particular therapist who adheres to this reunification type process that these programs that this bill is aimed at.
Okay. And again, we're just looking at your experience. You haven't seen this. Have you heard of this? Have you heard of therapies like this?
Yes,
you described it?
I'm fully aware of that. It's more prominent in other jurisdictions. Williamson County, I'm aware of a number of cases in Williamson County, and I think your case in Williamson County? Travis County. In Travis County, and some of the major metropolitan areas, Dallas and Houston, it's more prominent. Here in the hinterlands down in Hayes County, we don't get a whole lot of those cases.
Your Honor, Ms. Mudd spoke of a provision in the bill, and it's begins at the bottom of page 1 and line 21. In determining whether to order a party to participate in counseling, the court shall consider evidence of family violence or sexual abuse in accordance with 153.004. If credible evidence of family violence or sexual abuse is presented, the court may not order counseling in which a victim of the violence or abuse participates in counseling sessions together with the perpetrator of the violence or abuse. Again, we give courts a lot of discretion, but there's also a lot of the court may not, the court shall not. What does that sound like to you? Based on your experience, does that make sense to you?
That is entirely consistent with the position the legislature has taken. We do that for mediations. Previously, this legislature has amended the mediation statute because when they first adopted mediation statutes that ordered people to go into mediation in both sections of the Family Code, Title I for divorces and Title V, there wasn't language that protected victims of domestic violence and forced them to go to in-person mediations with potential people that had abused them. And so the legislature said, wait, you have to put in place protections for individuals. We're not going to put them in the same room with someone that's abused them. And I think this is entirely consistent with that. I think it's entirely appropriate.
Good. Thank you. I may have more questions, but I'll yield for
Certainly.
Senator Johnson. Thank you, Judge.
Thank you also. And I'm not familiar with these types of orders. Do the orders that you issue typically, or other family law judges issue, typically get into this level of detail as to what a counselor can and cannot recommend or require?
Usually they
I think I heard you say you don't.
They don't. Usually it's, as I was telling Chairman Hughes, it's just parent A is ordered to participate in family counseling. The parties are ordered to attend counseling based upon the schedule set by the counselor, and the parties are ordered to follow the recommendations of the counselor.
And so if this were to become law, I imagine you would have to have some sort of attestation from each recommended counselor that they will not engage in these practices, or the order itself would have to delineate what cannot be done in order to ensure that your order complies with the law, correct? I'm just thinking through the practicalities of this.
Exactly, and I would also think that good practitioners, and this would be part of an education process, would make sure that they touched upon that during their testimony of the individual, because it's likely they're going to have to, as I mentioned, put on evidence to convince a court that this is an appropriate appropriate therapy, and in order to do that, they're going to have to have experts come in and testify. And I think one side or the other is going to say, well, are you going to require this? Or are you going to require that? And they'll go through this laundry list.
Especially if this becomes law.
Exactly.
This bill's not without controversy as it comes over from the House.
Which is why I was testifying on it and not in
so I want to
favor
go
or
through
against it.
a couple of provisions. Chairman Hughes already went through one of them. I don't think anybody thinks that it's improper for us to prohibit a court to order that the victim of family violence participate in counseling with the perpetrator of the violence present, right? So that check mark, dropping down to subparagraph 3 on line 16, a court can order the transportation of a child to a location by force, threat of force, undue coercion, or other action. That seems pretty uncontroversial. A temporary or permanent change in the periods, not sure what that means, or the use of force, threat. So that there's various paragraphs in here at the top, the middle, the bottom, that I don't think any judge would ever approve of. We just don't talk about it in the orders all the time. And then there's other paragraphs here that are a little more troubling, and I'd invite anybody to comment on paragraph 1. I don't know if I'm reading this correctly, but a court can't order participation in counseling in which the counselor requires isolation of the child who's the subject of the suit from the child's family. Now, I presume you would want, perhaps, if there's evidence of abuse, sexual or other, that you might want the counselor to order isolation from the potentially abusive parent, right? So that may be something that needs to be fixed in the bill if it's going to move forward. You don't want them...
Because the scope is so broad. It could, but you do have situations...
It may conflict with itself.
Right, because there may be situations where there's a concern that grandmother or grandfather are coaching the kids or talking to the kids, or when the alleged abuser's the father or the mother. All right, so you have that situation, so you may want to limit, but you may not want to limit siblings. And child's family includes siblings, as you heard from the witness earlier. They weren't able to talk to one of their older siblings.
And so presently, the discretion over all this is essentially left, as you've described it, with the counselor.
With the counselor.
This statute is designed to take away some of that discretion because we have some evidence that that discretion might not have been employed very well.
Correct.
Okay. Just trying to get a frame on this.
Senator Johnson, may I comment? I think you asked if we had any opinion of that section.
I did invite the whole panel to comment.
Thank you. Because I would agree with your assessment of that section, including, for example, isolation from community. And so the concern I think many of us have is, if that's the case, when is it possible that we would be able to bring our children to therapy or counseling, given the fact that that section of the bill in particular prohibits isolation of children from this extensive list of circumstances? It's just troubling that my goal is indeed to prevent kids from being in an abusive situation of any kind, and that's why I'd prefer to say abuse, not just domestic violence. But then I'm also just concerned that if we can't remove the kids from this list of circumstances to do so, when do we do so? How do we clarify that in the law so that it's clear to the attorneys, and the judges that there are circumstances in which it's appropriate and right to make sure that we're in counseling together.
And thank you for your testimony. Thank you for your excuse. Thank you. We'll continue with public testimony, and I'll announce that we may have to cease the hearing so that we can go into the Senate session, but we'll go a little longer if we need to. Please, if you'll leave the, yeah, there we go, right there. Thank you. So we're gonna honor the 2-minute time frame so as many folks can be heard as possible, and we will see if we can push through. The chair calls Claudia Ovales, Sandra Aguilar, Charles Verdict. After them, we'll be looking on our next panel. We'll be looking for Taryn Champagne, Lisa Rothfuss, and Tyler Hubble. So y'all be ready to come up next, please. All right. Thank you very much. We can over here pull the microphone close, introduce yourself, and go ahead. You have 2 minutes.
Thank you. Thank you, Senator Hughes and committee, for your service. My name is Claudia Ovias, and I'm here today to oppose House Bill 3783 for the unintended consequences this bill will have on our service members and military community. That's something that's not addressed in the bill. The bill analysis states that this bill has been enacted in many states. It has not. As a veteran advocate, I have opposed this bill in California, Florida, Colorado, Maryland, Pennsylvania, Utah, and now Texas. The judiciary in California and Maryland have opposed it because it attempts to remove judicial discretion. And just 2 weeks ago, the Arizona Governor, Katie Hobbs, vetoed this bill. And I have a copy of that if needed. And it was vetoed for unintended consequences. This bill looks good on the outside, but when you look at it and who it's going to impact, that's not being addressed. Who wouldn't want to protect children? We all do. But this bill does not address all that, especially in that portion when we discuss isolating the children. It's not just about isolating children that have been sexually and physically abused. There's also child psychological abuse, and that needs to be addressed. This bill is a problematic federal bill that was enacted in 2022, referred to as Cadence Law. Often service members deploy and return home. They face divorce and separation. They often seek reunification in hopes to rebuild the relationships with their children who they were absent from. As a Marine veteran and a military spouse, we represent 2 of the 6 armed forces, and we've experienced this. I was court-ordered for reunification with my son. However, it was sabotaged. The other parent interfered constantly. So any progress that we got, it was 2 steps back because of his constant interference and noncompliance with the court order. My court order did not include a timeout or brief separation to allow therapy to work, and as a result, there was constant interference. My ex refused to get the help that he needed to support our co-parenting and support healthy relationships. I brought my concern to the sponsor on April 7th by asking to discuss the bill as it pertains to the military community, and the office's response was there was no carve-outs for the military community, and this bill applies to everyone. So again, I oppose this bill because a section of this bill would not allow a child who is a subject of the suit to stay overnight or for multiple days in an out-of-state location. So in this situation, what happens with those service members that live out of state and the child has to travel to them? Thank you so much. Again, I oppose this bill, and I request that you vote no.
Thank you. Thank you for being here. Welcome. Introduce yourself and go ahead.
Yes. My name is Sandra Aguilar, and I'm also here to oppose the bill. And I kind of feel like those of us who are 50 and older and remember the show Lost in Space and the robot that would say, warning, warning, and they kind of feel like that person this morning about there's a lot of things that are being said, shared today that are not completely factual, and that there is research, there are documentation. I've been doing this work as a licensed professional counselor. I've been doing it for 20 years. I think my first domestic violence case was with Mr. Salinas, who testified earlier. I have cases with Jeff Diamond. And I've been doing this work for a long time. And so these are not just cut and dry cases that you can just put like a pattern on it. And there are a lot of different dynamics that happen. One of my concerns is just the use of family violence and sexual abuse. Why not just abuse? The code already defines all the different levels of abuse, psychological, emotional, because of all the different things that take place in the situation for children. The other concern that I have is credible evidence. As a guardian ad litem and a child custody evaluator, I have interviewed children lots of times, plenty of times, and even in judges' chambers, and with children. And what sounds credible to one, the evidence does not always support. So there's not a real definition for what is credible evidence and how do you define that. So reunification therapy, the term for reunification is you're putting something back together that seems to have been divided. But it typically follows the language of family therapy. My concern also with this case is if there is a hearing and it turns out by chance, Senator Hughes, that the parent that has actually brought the lawsuit is abusing, it doesn't leave them a way to reconnect and reestablish that relationship with their child. It can work on both ends. And that's another concern I have. I don't disagree with a lot of the language. I think it needs some tweaks, and we have some suggestions for some tweaks if y'all are open to them. But, you know, I'm boots on the ground in this work, and this is what I do, and it's not easy work. And you want the importance of both parents in a family.
If you have suggestions, you should definitely get them to the sponsor, Senator Parker's office. We'll look at them as well, but he's your primary driver on this one. Of course, we're all going to work together. I want to make sure I'm clear. So the prohibition in the bill that says the court may not order counseling with the victim of violence or abuse participates in a counseling session with the perpetrator. So you're okay with that, but it should be broadened to more than just.
So here's.
I'm not trying to argue with you, but it sounds like you're saying you want it to do more than it does.
So I think I can answer that better with an example. So when I worked with Travis County Domestic Relations Office, I was specifically assigned to the protective order docket under Honorable Rhonda Hurley and Susan Shepard and Judge Jean Muir. And in a protective order case, they would often order supervised visitation and even possession and access. So that's an important factor that we also need to consider. This is strictly saying family violence and sexual abuse, but if that is what's in place, a parent can go get a protective order also. And in those cases, often there is possession and access for those children with that parent.
So I misunderstood your testimony. It was not what I thought it was law. Thank you. Yes. Welcome. Introduce yourself. Go ahead.
Thank you, Senator. My name is Charles Verdict. I handed to the clerk some materials. I want to go directly to the text itself. You are asking Ms. Aguilar about definitions in subsection C. My recommendation would be that it be amended to replace 153.004 as the source of definition of abuse with Family Code 261.001. That's a broader definition. It sweeps in things such as sexual abuse and a long list of other heinous acts against individuals or children.
So you're in favor of a law that says if there's evidence of any of that abuse, no counseling with the accused parent, or is that to make a point about the bill? I'm really trying to understand.
Yes,
I'm not arguing with you.
There I would make two edits. The one I just stated to change the definition set. The second in the same subsection in C.
I should have let you finish. Go
is to change the evidentiary threshold. Rather than it saying credible evidence, that the court must find. That the court must find. And that will help with interlocutory or final orders. And I wanted to touch on something that Judge Hayes said, and you heard it from Ms. Aguilar, that where there's domestic violence, the courts have discretion to create a safe place, both in mediation or possession and access, for that to go forward. And I've provided you proposed language where you'll see I've added a D1, which comes right out of the same sections that Judge Hayes says. And the D1 that I've suggested is notwithstanding the sections above, the court may order counseling under those sections where they render an order that is designed to protect the safety and well-being of the child and any other person who's been a victim of abuse committed by a parent. Adding back that makes sure that whatever therapy is happening is safe and that the court has a command from the policymakers here to make sure that that order is complete. 2 quick points. I know I have 19 seconds. One, you have a copy of the Texas Supreme Court. Mandamus was denied in 22-0542. It was right on point. Reunification, parental alienation. Last point on that is that if passed without edits, this will not survive scrutiny because it says that a fit parent who's exercising their exclusive right to obtain a lawful therapy cannot do it.
Thanks for your testimony.
Thank you.
Thank you very much. Thank you all for being here. Chair calls Taryn Champagne. Okay, Lisa Rothfuss, Tyler Hubble, Tariq Farouk. All right, welcome. Just pull the microphone. We'll start with you and pull it. We'll go from my left to your right. So pull the microphone over to you and get started, please. And there you go.
Okay.
Get a little microphone a little closer to you.
Is that good there?
Get a little closer.
All right. Senator Hughes, committee, thank you so much for this opportunity. I'm full of a lot of different motions. One of them is just gratitude for everything that we've heard, as well as
introduce yourself to us. And
that would be good.
Okay. All right. You're fine.
My name is Tyler Hubble. I'm here to testify against House Bill 3783. I am a parent who's currently working in reunification therapy with my 2 amazing children. It was heartbreaking to hear that first testimony of everything they went through. Like you heard before, it is a very disorienting situation, and from both sides you will hear similar things, and there is a large amount of judicial discretion that needs to be made. I've read some of the testimony, and I hear concerns over judges making errors in judgment. I don't think this bill rectifies that. It calls in a lot of question. I do want to take a little bit of time just to say, like, some of my children's experiences that I've seen as a parent, because these are symptoms that a trained professional will be able to split out. My children who previously, loved to eat, would even cook their own food, would ask for seconds, thirds, went through a phase where they would say that they refused to eat anything in the house because they're afraid it would be poisoned, or just that the air in the room would poison it, and it would contradict any logic. As you can see, I have lived every year of my life without poisoning myself and have not poisoned anyone else. There have been several times when they, sorry, I lost my train of thought.
It's okay. It's okay. Take your time.
Yeah. When behaviors that just seem to come out of nowhere, and as a parent, you would want to be able to correct that. But there is a incomprehensible barrier in these children that does not allow a parent to be able to comfort them in that situation. They would loudly mock prayers, becoming isolated from their religious community, from their family on my side, as well as even some of their friends. These protective measures are sometimes needed to ensure the physical and emotional well-being of children in these cases. So I urge you to oppose this bill.
Thank you for your testimony. Thank you. Welcome. Get that microphone over, introduce yourself, and go ahead.
Thank you, Mr. Hayes and the committee, for taking the time to hear me.
My name is Lisa Wellens, and I am a licensed clinical social worker in Austin, Texas, who works with the court system in multiple counties where I am appointed as and have been a guardian ad litem, a parent facilitator, a parent coordinator, and provide reunification therapy for families in high conflict cases. I'm here to provide information and any clarification on issues with the bill. And from my experience as a reunification therapist in high conflict families for the last 10 years, and my experience as a licensed family and child therapist for 38 years. My name has been mentioned in today's hearing and was mentioned in the hearing on May 5th. And in that hearing, there were stories that were shared in testimony by family members that received reunification therapy, and I was one of the mental health professionals on some of these cases. And as such, I am aware of significant factual misrepresentations and omissions occurring. But I also would like to say that I have worked with hundreds of families that have been helped by reunification therapy in the last 8 years doing this work in the court system. I do believe, as a therapist, working with children and families for the last 38 years, that is absolutely crucial, and our job to protect children that are being abused. But House Bill 3783, in its current form, will not help alleviate the suffering of children in high conflict family disputes. Children who are isolated and deprived of a relationship with a parent, and a parent who has not engaged in any abuse, has not been proven to engage in any abuse, are at risk for significant psychological abuse. The legal system now has a clear and evidence-based definition to support identification and adjudication of psychological abuse cases. Parental alienation, a process in which one parent deliberately undermines the child's relationship with the other parent, fits within the Diagnostic and Statistical Manual under the definition of child psychological abuse and in the V codes of child affected by parental relationship distress. Family courts are increasingly recognizing this dynamic as a form of psychological harm that requires serious intervention. The intervention considered appropriate for these kinds of cases is reunification therapy, which has been around for 25 years and has been used in court system across the United States. Reunification therapy is a special kind of treatment meant to repair the relationship between a child and a parent who have been separated from one another for a length of time for various reasons. And reunification therapy allows children to receive therapeutic support while reintegrating an estranged parent back into their life. Without reunification therapy, children might not have any support when reuniting. And I think this would actually cause more psychological harm.
Thank you. Thank you for your testimony. Is it Mr. Farouk? Welcome. Get close to the microphone, introduce yourself, and go ahead.
Yes, sir. My name is Tariq Farouk. I'm the father of a profoundly disabled child born with a condition called tetrasome 18P. It's estimated that only 250 to 350 kids worldwide have his condition. I'm also the author of multiple IT books, a husband and a father who's excelled in every dimension of parenting, academics, athletics, personal development, and emotional presence. I have no criminal history, no restraining orders, no findings of any concern, yet separated and intentionally alienated from my kids by the horrible system of family law in this state. I'm a huge proponent of the equal shared parenting bill that's proven to have excellent results for kids, especially in Kentucky and other jurisdictions in the country. I was married for 18 years as a faithful, loving, supporting husband and father. I do, however, support some of the I am here testifying in support of the bill. I do, however, support some of the modifications to the bill that were proposed earlier by the opposition, especially considering the very low bar of preponderance of evidence standard within family law. I also do agree with the opposition about the redefinition of abuse reincorporated within this bill when other sections of the legislature have already done so previously. I am here specifically today to support HB 3783 because it is time to put clear limits on when and how courts can order counseling and therapy, and by merit of that fact, be part of parenting and family and what have you, essentially a restriction of government. Sidebar, I am also a huge Trump supporter. This bill ensures that children are not forcibly subjected to counseling and reunification, especially when a parent like me has credible concerns about the misuse of therapy as a litigation weapon or as a smokescreen for alienation. It is a necessary guardrail. It protects children, vulnerable children like mine, from being forced into therapy that serves litigation strategy rather than healing. So I urge all of y'all to vote yes on HB 373. But I do want to reiterate that I do agree and understand some of the concerns by the opposition. Thank you.
Mr. Farouk, thank you. And sometimes our technology doesn't, we don't always keep up with it. When you registered to testify, we have you down as against the bill, but I understand you, should we show you as for or just on, or?
I think that was a mistake.
Do I have your permission to, do you want to say for, against, or just on?
For, sir.
Put you as for. I'm not trying to, it sounded like you were for it, and we're taking note of your suggestions as well. Thank you.
Appreciate it.
And thank each of you for being here. Thanks for your testimony. Chair calls George Saldana. Mr. Saldana is the last witness who is registered to testify on, for, or against House Bill 3783. Anyone else present wishing to testify on, for, or against? Last call. Public testimony is closed, and we'll hear from Mr. Saldana, and then we will close this bill for today. Welcome. Good to have you in this committee. Introduce yourself and give us your testimony.
Good morning. My name is George Saldana. I'm kind of impartial to the bill because I can see it from both sides. I think we need to look through a different perspective. Like the Family Law Foundation and the Judge Hayes said, every case is different. We have multiple bills flowing through this House, and I'm talking both chambers for judicial accountability. They're judges that are constantly getting it wrong on both sides. That's the common denominator. So we have both sides coming and feuding about which reunification therapy process should begin. But if we pay attention to the rule of law, and let's go through the SJRs that have been flowing through this building for parental rights, medical, educational, and parental rights bill, the umbrella of parental rights, SJR 34. It says governmental interest, a compelling governmental interest. Before you can limit, restrict, or terminate a parental right, and in that compelling state interest, it must be truly compelling, it must be narrowly tailored, least restrictive before you can do that. Now, in the Starry case, Starry v. Etheridge just came down 2 weeks ago from the Texas Supreme Court. Justice Bland wrote that opinion, and in that opinion on page 8, both these courts and Supreme Courts of the United States have long recognized the fundamental right of parents to make Texas law rightly require that before infringing on a parent's right to care and have custody of their child, they must demonstrate to a court that government intrusion is warranted. Child welfare is an issue, but it requires a clear and convincing evidence standard before you can start limiting and restricting a parental right. And I close.
On this bill, do you want to be shown for?
Impartial.
For, against, or on? On is normally, I'll put whatever you want.
I'd like impartial. I'm in between.
So we're going to put you as on the bill, if that's okay with you.
Sure.
That's the closest we have to impartial. We only got to pick one of
them. This is way above my pay grade. This is for judges, but until we have judicial accountability ruling on the rule of law, that's when all these litigants here are going to come together and find unity. Thank you.
Thanks for your testimony. Those are all the witnesses we have registered to testify on, for, or against House Bill 3783. Public testimony is closed, and the bill's left pending at this time. And with thanks to our excellent committee staff and each member and the Senate team that keeps us running, and for each witness, regardless of your position, it's important. Your testimony matters. The Committee on Jurisprudence stands in recess, subject to the call of the chair. Good morning.